Mr. Chairman.
My Lord, can I begin by drawing together the various submissions that I was developing yesterday afternoon as to why we say the Brutus allegations appeal falls to be dismissed? And can I begin this morning by reminding the Court of the two grounds of appeal that the appellant relies on in attacking the judgment below. They are in the appellant's notice, of course, at 4 bundle tab 1, starting first of all at page 17, paragraph 2. And my Lords know that there are two grounds of appeal relating to the Brutus allegations. The first is what appears at paragraph 2 and is described as the speculative allegations point, which is the argument that the claimants have uncritically adopted allegations of dishonesty made by a third party, of which the claimants have no direct knowledge, doing so without first subjecting those allegations to any or any adequate investigation and verification. And the second ground of appeal appears over the page at paragraph 4 and is called the no primary facts point, and is to the effect that the claimants have failed to plead all or indeed any of the primary facts on which they rely to justify an inference of fraud and dishonesty, and or have failed to plead primary facts capable of supporting such an inference. Now, my Lords, as to the first ground of the respective allegations point, two submissions in answer and summary to that. The first is that there is no obligation to plead or lead evidence as to the verification or investigation that the claimants have undertaken before pleading their claims. The question is simply whether the pleading is a proper pleading on its face. The second is that there is no objection, and can be no objection, to pleading allegations by reference to allegations made by a third party, for the reasons that I sought to explain yesterday. As to the second ground of appeal, the primary facts point, perhaps three submissions in summary. The first is that it remains unclear, with respect, precisely what primary facts the appellant says should have been pleaded and are not. And with respect, my learned friend somewhat struggled to identify yesterday what was or was not a primary fact by reference to what had been pleaded and what had not been pleaded and what he said should be pleaded. The second summary submission in answer to the second ground of appeal is that in any event, the pleading does plead perhaps what we would more accurately call the essential factual building blocks of the cause of action relied upon. And so in particular, my Lords, it pleads, first of all, the statements and omissions which are said to constitute the relevant statements and omissions in and from the published information. Secondly, it pleads that those statements were false because of the relevant misconduct. And thirdly, the pleading pleads that those statements and omissions were known to be false or omissions by PDMRs, or at least that PDMRs were reckless as to their truth. Now, the third summary submission, my Lords, is that the inquiry on this appeal, of course, is focused on the second of those three elements of the cause of action, the particulars of falsity, and in particular, the particulars of falsity based on the relevant misconduct, and within the relevant misconduct, the particulars of falsity relied upon by reference to the Brutus allegations, which are pleaded, as we know, at paragraphs 24, 25, and 27 of the particulars of claim. And we say, and I'll have to just say one or two more words in addition to what I said yesterday as to why we say, that on their face, those paragraphs are perfectly adequate and proper pleas. Now, my Lord, as my known friend Mr. Beltrami confirmed yesterday, the attack on the pleading and the focus of his grounds of appeal is on those two, what he described as fundamental points, i.e. the speculative allegations point and the no primary facts point. The attack on the pleading is not, as he confirmed, one where it is said that the case should be struck out for want of particularity. And that's what my learned friend told my lords at yesterday's transcript, page 80, line 23, to page 81, line 3. And my lords, that's not surprising with respect, because under CPR Rule 3.4, as my lords will be all too aware, there are only 3 bases upon which the court can strike out a pleading, and all 3, somewhat strangely, are relied upon by the appellant here, or certainly were relied upon in the application notice. The first is that there are no reasonable grounds for bringing the claim. The second is abuse of process. And the third is a failure to comply with a rule or practice direction or court order. Now, my lords, addressing those in reverse order, first, there's clearly no breach of any rule, practice, direction or court order, and none is really suggested. Equally and secondly, it's not really suggested that the pleading is abusive or vexatious so as to fall within Rule 3.42b. And so what seems to be being suggested is that this is a Rule 3.42a case, where what seems to be being suggested is that the judge was wrong to fail to conclude that the pleading does not disclose reasonable grounds for bringing the claim that it does. Now, my lords will understand we say that's wrong, that the pleading plainly does disclose reasonable grounds for bringing the claim, and that's the appropriate litmus test. Now, when it comes to a pleading in deliberate wrongdoing, dishonesty or fraud, the reasonable grounds for bringing the claim carries with it some particular requirements, and we accept that. And those are helpfully summarised, as my Lord Justice Phillips suggested that they were to my learned friend yesterday, in the decision in SOFA. And it may just be worth very briefly turning that up again, please, which is in the authorities bundle, tab 14, at page 396. And could I just invite my lords to remind themselves as to paragraphs 23, 24 and 25 of the judgment of Lord Justice Arnold, please. Now, my lords, paragraph 23 might be described as effectively summarising the threshold test for the pleading to satisfy on its face, and paragraph 24, by way of perhaps additional explanation, sets out what I have perhaps inelegantly described as the fitness for purpose test. Now, we say that the tests set out in both paragraphs 23 and 24 of this judgment are satisfied here. The pleading alleges deliberate misconduct in terms and sets out how that deliberate misconduct came to manifest itself. In addition, the fitness for purpose test is satisfied, as the judge found. The parties have joined issue on the pleadings. The issues in dispute are sufficiently clear. And as to that, the parties are now embarking upon disclosure by reference to those issues. And to be clear about that, my lords, disclosure, of course, must be given and is going to be given in relation to the allegations of relevant misconduct. And perhaps picking up on a point made during the course of argument yesterday by my Lord Justice Coulson, once provided, and this has been accepted incidentally by both parties during the course of the two major case management conferences that have taken place in this case, once provided, the disclosure is likely to lead to a narrowing of the issues. We anticipate by amendments on both sides, so that once we are at trial, the focus will be on any remaining disputes as to the scope of the relevant misconduct, insofar as it is relied upon, both to demonstrate the falsity of and omissions from the published information, and the knowledge of the PDMRs about that. So in terms of fitness for purpose, the pleadings flowing through disclosure permits, or starts from and permits, a bottom-up analysis. But by the time of the trial, the position is being pragmatic and realistic about this, likely to be much more focused and permitting more of a top-down approach. But again, the fact that that is happening, as recorded by the judge in his judgment, reflects the fitness for purpose of the pleadings. And my Lord, just to return to the pleadings, perhaps 4 short points. The pleading pleads in paragraph 27 the allegations and particulars of the wrongdoing relied upon. Second, the basis for that plea...
Sorry, just hang on.
I'm sorry, my Lord.
So sorry, your first point was?
The first point is that the pleading sets out the allegations and particulars of wrongdoing in paragraph 27 of the particulars of claim. The second point is the basis for that plea, for the plea of wrongdoing, is found both in paragraph 27 itself, which pleads what I've described as the factual building blocks to an extent, and in summary form. So, deliberate or systemic course of conduct in developing a Iran business in breach of sanctions, the use of online and or fax banking, all the building blocks of this is the misconduct that we say was relied upon. But is also to be found, the basis that is for the pleading of the wrongdoing is also to be found, of course, in paragraph 24. The third point is that when read together, paragraph 24 and paragraph 27, together with the explanation and definition of relevant misconduct in paragraph 25, comprises a proper and adequate plea of the relevant misconduct relied upon in relation to Brutus. They set out, this is what we say you did, and this is how you did it, and we say you did it deliberately. Now, my Lord, the pleading could have stopped in doing that, but my fourth point is that the pleading in paragraph 24 then goes further, and beyond that which is strictly necessary for the pleading, by identifying the source that is relied upon to support the pleas, namely the allegations made in the Brutus complaint, and that they were made by a standard chartered whistleblower. Now, as I sought to suggest yesterday, to an extent, that is the pleading of evidence. It is unnecessary, taking the example as I did again, of that postulated by my Lord Justice Phillips during the course of argument, of where the whistleblower, instead of bringing proceedings, walks into the solicitor's office and unburdens himself. The pleading could have been pleaded without reference to what by reference rather to what the whistleblower had said, but without identifying that the information had come from the whistleblower. Now, the approach of the claimants in this case, and to an extent the defendant, as I'll come on to show, has been to plead the source of the pleaded allegations. Now, from the claimant's perspective, we would suggest that's not surprising in circumstances where it is in the nature of this type of action that the allegations are highly unlikely to be within the personal knowledge of the claimants themselves. So in order to bolster the allegations that they make, and perhaps to an extent forestall any summary judgment, not strikeout, any summary judgment application, the claimants not only plead the allegations in a perfectly proper way, but set out the basis or sources that they rely upon in making those allegations. Now, my lords, I've indicated that that's the consistent approach to the claims, and it is. Can I just very briefly, I hope, go back to the pleading, but to start this morning with how the case is put by reference to the 2019 settlements, as to which, of course, no complaint has been made. And one sees that at Core Bundle tab 7, page 114, where the various settlements are identified in paragraph 21, and then documents relating to or giving effect to those settlements are identified and defined. And then allegations in a materially identical way in terms of approach to paragraph 24 are then pleaded. So, for example, at 21.1, there is an allegation that, contrary to statements in the 2012 settlements, unlawful payments continue to be facilitated by the bank from 2008 through 2014. An additional $600 million of payments were made in violation of US sanctions. So the allegation itself is cast at the same level of particularity, if I can put it that way, as the allegations in paragraph 24. And then a reference is given here, a reference is given to an underlying document or piece of evidence as the source or basis for that allegation. In this case, the consent order with the NY DFS and a paragraph number in that consent order. And a similar approach is adopted throughout. So paragraph 21, 22, which refers to the statement of facts, and also 23, which refers to the settlements with the UK regulator, the FCA. So allegation is pleaded, a reference is then given to the source. Exactly the same approach is then adopted in paragraph 24. Allegation pleaded, and the source then identified. Now, as I've said, the claimants need not have done that. They need not have identified the source they rely on for further details of and the evidence in support of the allegation that they make, that they have. The defendant has done, in approach, the same, or at least a very similar thing. And so if one turns up the defence at tab 8 in the same bundle at page 220, my lords, and paragraph 24.1 at the bottom of page 220, no issue is taken, as no issue is taken in the pleadings, about the approach of the claimant, namely, plead the allegation, plead the source. What the defendant does is it joins issue with the allegation that the claimant seek to draw from the 2019 settlements, and then itself, the defendant itself, give cross-references to the underlying documents which it relies on in support of that joining of issue. So one sees, for example, in 24.1, a positive case is pleaded as to what the settlement in fact says in answer to the allegation that's pleaded in the particulars of claim, and that at the end of the paragraph, in a similar way to the approach adopted by the claimants, a cross-reference is given to the underlying document. Now, when it comes to Brutus, again, a similar approach is adopted, and Brutus is addressed at paragraph 26, but the paragraph beginning at paragraph 26, but I was going to invite my Lord's attention to paragraph 27, starting at the bottom of page 223. Because what the defendant does here is it says, well, the Brutus complaint was the subject of a motion to dismiss by the US Department of Justice. And the evidence in support of that motion included declarations from individuals who conducted the US agency's investigations. And then a positive case is pleaded as to what that evidence explained. And one sees, for example, at paragraph 27.1, though the same approach is adopted throughout, the allegation that the US agencies extensively investigated the allegations made by Brutus, and so forth. And then instead of putting the reference for the evidential basis or source for that averment at the end of the paragraph, there's instead a footnote 13 on this occasion. And then footnote 13 pleads the various sources upon which the defendant is to be taken to be relying in support of the pleaded case. And that's an approach that's adopted throughout. Effectively, this is what we, the defendant, says happened in the United States proceedings, and these are the references to the evidence upon which we rely in support of that pleaded case. And that then leads, for completeness, at page 225 to paragraph 30, where the relevant misconduct, insofar as it relies on the Brutus complaint that is pleaded at paragraphs 25 to 27, is denied, and it's denied for the reasons set out in those foregoing paragraphs, paragraphs 26 to 29. So a similar approach adopted by both parties to pleading their cases. Perhaps not surprising, given the breadth of the issues and background material, the period of time, the allegations, and so forth that the pleaded case covers. So to return to our approach in paragraph 24 of the particular claim, what we do there is seek to identify, as we do for the 2019 settlement, and in a similar way, indeed, as the defendant does in its defence, the source or sources of the claimant's knowledge for the pleas that we are making in the pleading. We don't need to do that in order to make a proper plea, but the claimants have chosen to do so to demonstrate the credibility of the allegations, and as I've indicated, potentially to forestall any summary judgment application, albeit that one was in the event made. In effect, what the claimants are pleading is, we allege X, that's the allegation pleaded in paragraph 24, and X is credible, and the claimants believe it to be true, because the source of allegation X is either the 2019 settlement or the Brutus complaint, as the case may be. So then when it comes to what the statement of truth covers on the pleading, to return to the question that my Lord Justice Newey asked me yesterday, the statement of truth attests to the claimant's belief that the pleaded allegation X, as I've just called it, is true, and by extension, that the basis of that belief, that is the 2019 settlements or the particular parts of Brutus, are also believed by them to be true. And so when, if one returns to perhaps paragraph 24.4, about which I was asked yesterday, at page 119, tab 7, page 119 in this bundle, true it is that 24.4 does not identify particular paragraphs in the complaint, but it does, in the same way as the other subparagraphs, identify the source of the allegation, namely the complaint. And so qualitatively, the position is in substance the same as the other subparagraphs of paragraph 24. This is the allegation. The source of the allegation is the complaint. And to the extent that the complaint makes this allegation, the claimants also believe that to be true.
So can I be specific? If we look to see what is identified in the complaint, you find that in paragraphs 46 to 59. Do we take it that you are, by your statements of truth, confirming that you believe those paragraphs to be true?
My Lord, yes. And there is, in fact, I think, to be more precise, it's 46 to 51 and 56 to 59 are actually the transactions. But it's,
sorry, can I get those? So
yes, 46 to 51 and 56 to 59, because it's those paragraphs which contain the...
it's not 59, is it?
Well,
you need 59 for the last sentence.
59 provides the figure.
Yeah.
Now,
I'm sorry, I won't stop you. You're in the middle of finishing this point.
my Lord Director, the point that I was just going to make about that is that, well, the 2 points. The first is that this has caused no real difficulty. In fact, in the course of debates about the scope of disclosure, the defendant has contended that paragraph 24.4 must be referring to those paragraphs in the complaint, and has then, we would say, wrongly suggested that any disclosure must be limited to the example transactions that are identified in those paragraphs, which obviously we've said is wrong because they are only examples. And the final point, and then perhaps I should pause to allow the question to be asked of me. The final point is that I was no doubt guilty of being less than as clear as I ought to have been yesterday afternoon explaining this, because one has to be careful not to say anything that contradicts the basis upon which we resisted this application before the judge. And one of the things we made clear to the judge, and remains the case today before this court, is that we do not rely on the complaint in full. And my lords will understand why that's the case, that the complaint is pleading a different cause of action in a different jurisdiction and in a different way, necessarily, from the way in which the claimants need to plead their case relying on a different cause of action in this jurisdiction. And as a result, it contains matters that are simply irrelevant or unnecessary for our pleading. So I wanted to be clear that, well, where there's a reference to the complaint, we're not saying, well, that we're relying on everything.
We're not taking the whole thing. One other specific one, which I can't remember whether you dealt with this yesterday or not. The last sentence of 24.3 hasn't got a reference, but the reference in the complaint seems to be 43E. Do we take it that you believe that to be true?
Well, my lord, yes. The same applies. Wherever we're identifying the source, the statement of truth is attesting to the truth, belief in the truth of the allegation, and the belief in the accuracy of the source as well.
And, I mean, obviously, with that sentence, you haven't identified the source exactly, but you do refer to the source being the complaint, and the relevant bit of the complaint seems to be paragraph 43E.
Yes, and in fairness, the position goes slightly further than that, because we plead later on in the pleading to the engagement of Promontory, the consultant, and its involvement in the US regulatory authorities' investigations.
Yes, I see.
I'm sorry, Lord.
What I wanted to ask you, it may be you're coming on to this, but you've rightly identified the way that you have structured your plea, referring to the source being the Brutus complaint, and you refer to the defence adopting a similar pattern of setting out material response. I think what you haven't addressed yet, maybe you're going to, is the point made against you is that when you chose to set out the source of the information, solely the Brutus complaint, and what the defendant has pleaded back to that, and the only thing it can plead back to that, in a pleading sense, is, well, that complaint has been dismissed on the basis that the government on whose behalf it was brought has determined that the allegations are meritless. So if one looks at overall at what you've set out, you have set out and expressly set out complaints, allegations in the complaint, which the claimant in that case has itself accepted are meritless. And that's why it said that this claim has no solid foundation. And that, yet, I don't think you come to address.
Well, Lord, the way we sought to address that, perhaps I didn't address it yesterday as I had intended to, is by taking issue with the way that the defendant now seeks to characterise the claim. Because the way the defendant seeks to characterise the claim is the claimants are simply saying Mr. Knight, through Brutus, alleged X, Y, and Z.
It doesn't even say that.
Or
It doesn't mention Mr. Knight making any allegation. All it says is that he owns Brutus.
Well, let leave perhaps that point on one side. The attack on the pleading is you are just pleading allegations made by a third party, and you're not adopting those allegations as your own. Now, the response to that is that's an inaccurate reading of the pleading. When you look at the paragraphs, as we did yesterday, I think, paragraphs 25 and 27, because paragraph 25 makes it clear in defining the relevant misconduct that the misconduct relied upon is the subject matter of paragraph 24 above. So the claimants are making these allegations themselves, that this is what Standard Chartered did. This is what the judge found. That
Yes, I understand that, and that's one aspect of the attack. But I think the other aspect is, to the extent that you have identified what you're relying on, it is firmly based on what is in the Brutus complaint. And the fact that it is in the Brutus complaint, and what the defendants say is, well, that is written water because that complaint has been dismissed on the basis it has no merit by the claimant.
And the response to that is, firstly, the judge below was not in a position to assess the two competing cases in the United States. There was no dismissal on the merits. You had, on the one hand, Brutus saying, on the basis of the evidence of Mr. Knight, Mr. Marcellus, and Mr. Chandra, reminding ourselves that Mr. Knight and Mr. Chandra were former employees of the bank. Mr. Marcellus undertook substantial business with the bank, giving first-hand evidence as to this wrongdoing. And on the other, the US government, not the bank, the US government saying, we don't want to adopt this action because we consider, for its own reasons, that the claims made by Brutus, supported by that evidence, are without merit. Now, there was no determination on the merits of the Brutus complaint in the United States. Those were the rival contentions.
Forgive me, there wasn't a determination on the merit because the party in whose name the proceedings were being brought, namely the government, itself said there's no merit in them. So, in a sense, you couldn't have a more thorough determination on the merits in that the claimant itself said, I accept there's no merit in it.
Well,
that's the point against you.
My lord, that is a point that's taken against us. And the judge was right to reject it for the reasons he gave.
Where did he reject it?
If one looks at the judgment in this same bundle, tab 5,
Yes.
Page 68. Page 68, paragraph 56, is where the judge deals with the first point, which I was addressing my lord about a moment or so ago, namely whether the claimants themselves are making this allegation. At paragraph 59,
That's the verification point.
yes,
I'm not sure it's been really pursued on appeal.
I think that's right with respect, my lord, yes. And then paragraph 60 and 61 deals with the basis upon which one has to be slightly careful here, because are we in strikeout or are we summary judgment territory? Because the application below was brought on both bases. On appeal, in effect, my learned friend is confining himself to strikeout. Now, on the strikeout test, we would say the short answer is one doesn't get into what happens in proceedings in the US and what the US authorities said. Does the pleading on its face satisfy the test we were looking at in SOFA? Answer, yes. But to the extent that it's being said, well, there are no reasonable grounds for bringing the claim because of what happened in the United States, then that is addressed in paragraph 61, where the learned judge below identifies the evidence that explained why the claimants had reasonable grounds for making the Brutus allegations. And he then summarises some of the points that were made, including that the three individuals who I've just identified made declarations under penalty of perjury supporting in their evidence the allegations made in the Brutus complaint. And one sees, I won't read it out unless my lord wants me to, the various other points made there in terms of the volume of evidence, that some of the allegations have actually proved to be demonstrably correct. They don't have the look or feel of fabrication or speculation. The previous admissions by the bank. And then at subparagraph 7 is the point that I was just addressing my lord on in answer to my lord's question, as to there being no determination in the United States on the merits. And paragraph 8, or subparagraph 8, deals with the point that I think my lord was just making to me about the US government's own stated position and why that may be explicable either on the basis of incomplete information or motivated by other factors. And what the judge then does, having identified those various factors, at paragraph 62, reminding ourselves again that the attack being made was slightly different. It was really the one that's now not being pursued, i.e. the verification point, is say that some of those points are stronger than others, but on balance, the claimants are entitled to take them into account in assessing whether there was sufficiently credible evidence before them to justify making the Brutus allegations. So the judge there identifies, we say, correctly, albeit dealing with both a summary judgment and a strikeout application, and also dealing with an attack that was focused really on a point that's not being pursued on the appeal, absence of verification, with why there were reasonable grounds for bringing the claim. And he finds that there were for the reasons he sets out. And we say he was right for those reasons, or certainly can't be said to be demonstrably wrong.
I think the real gravamen point, I can see that you can adopt these allegations and feed them all out on the basis of information you received, particularly from Mr. Knight. And that probably subject to arguments about whether it's sufficiently particularised. But your pleading is solely based upon the Brutus complaint. It is, in fact, when you first read it, it doesn't actually make allegations. It just simply says these allegations have been made. It's only based on the Brutus complaint. And as the defendants then respond in detail, this has been dismissed on the basis that it has no merit according to the claimant. That I think, is the force of Mr. Beltrami's point, that on the face of it, your claim is solely based on a complaint in the United States, which has in fact been dismissed That's why he's able to say this case has no firm foundation, as pleaded.
And the response to that, Lord, is really the one that I've given by reference to the judgment, which is there is a firm basis. There may be disputed issues of fact. I mean, for example, this perhaps isn't actually disputed. The jurisdictional basis upon which the claim was dismissed, there was no determination on the merits. The US government, this is a particular form of action which a relator can bring in the name of and for the benefit of the United States government. And the United States government then has locus to effectively intervene and disclaim the claim brought on its behalf. And that's what it did. And it led to a dismissal of the claim on the particular basis, applying the particular test that the US court did. And that required no determination on the merits of the underlying allegation.
Yeah, the US government stood to receive a very large sum of money from this action based on where a third party that is doing all the hard work to enforce the US government's sanctions regime. So they're not going to go and have that dismissed lightly, are they?
Say for the matters identified by the claimant and relied upon by the judge. And the difficulty here is that the allegations really goes back to the point I was making earlier this morning and indeed yesterday. The allegations could have been made, and I do say, with respect, the allegations are pleaded as allegations being made by the claimant when we read paragraphs 24 with 25 and 27. And the allegations could have been made without identifying their source. Going back to the example of the whistleblower who unburdened himself to the claimant solicitor in a confidential way. The fact that the allegations could have been made in that way and constitutes a proper pleading can't then be undone in our submission by the fact that the claimants have gone further than required as a matter of pure pleading, for reasons that I've sought to explain, in identifying the source upon which they've relied in both making those allegations and then attesting to their belief in their truth of those allegations.
Well, I think the way Mr. Beltrami would put it is, well, it isn't a matter that you've got, what you've done is identify the extra material you identified has demonstrated why there is no foundation for it.
Well, that may be the way he puts it. I'm not sure it was the way he put it on the appeal, but he'd be, with respect, he would be wrong to, or that submission would be wrong, because there is a solid evidential basis. There are reasonable grounds to use the test for making the allegation. The allegations are based on that which we've seen that has not yet been tested in any court, still less by this court, on the merits. And that is a reasonable ground, a more than reasonable ground for making the allegations. And there are explanations given as to why the US government acted as it did. But the fact that the fact that it's a proper pleading in deliberate misconduct, dishonesty, is clear on the face of the pleadings. And if we're in reasonable grounds for bringing the claim territory, there are reasonable grounds for bringing the claim for the reasons the judge identifies in particular at paragraph 61 and 62 of his judgment. Otherwise, and this is the point that the judge makes, I think, earlier in his judgment, the court is proceeding in a way that the defendant itself said was itself objectionable. Because the defendant's position was, here are the claimants simply relying on the opinion of a third party. That won't do. We say, no, we're not relying on the opinion of the third party. We make the allegations ourselves, and we identify the source that we rely on when making the allegations. The defendant then says to the court, notwithstanding there's been no determination on the merits, strike out these allegations because the US government has formed the opinion, for whatever reason, that they don't want to adopt them. And that's what it really comes to. And the judge again was right in making that determination. So, my Lord, for those reasons, we say there's a perfectly proper plea and the two grounds of appeal fall to be dismissed. My Lord, so that brings me to Maxpower, and there are 3 points there. The first of which is ground 3 of the grounds of appeal, the de facto director's point. This is with respect to some unedifying battle over whether the judge was correct to proceed on the basis that the claimants do plead that the group executive were either de jure or de facto directors of Standard Chartered PLC. We say that the judge was right, and that's clear on the pleaded case, and I'll take you briefly to demonstrate why that's the case. We had tried to take this ground, at least, off of the table, so to speak, so that my lords would not be troubled by it, by putting the position beyond doubt, by amending the second response, or the response to the second request for further information. We could have done it, we could still do it through voluntary further information. But nevertheless, the defendant objects to us doing that. Interestingly, it seems to object on the basis of grounds 4 and 5. So if we actually said what we say we propose to say by way of the amendment, I think it's implicitly accepted that ground 3 would go, but the pleading would then still face the attack on the grounds 4 and 5. But there we are. We say in any event that the judge was correct. This does require a little bit, I'm afraid, of a trawl through the pleadings, and the position is complicated by the context, which I sought to introduce yesterday. That context arises from the decision of Mr. Justice Miles in G4S, and there are 2 points about this. The first is a point on chronology. G4S was decided on the 10th of May of 2022. And to fit that into the chronology in these proceedings, the particulars of claim were served on the 10th of November 2021. The defence was served on the 2nd of February 2021. 22, I'm so sorry. And as I indicated yesterday, self-evidently that's prior to the decision in G4S, the defence takes quite an extreme position on PDMRs the other way. It says only de jure directors of SC PLC are PDMRs. The reply was then served on the 1st of April 2022, so again before the decision in G4S. And on the same day, the 1st of April, the first RFI response was served. And then the second RFI response was served on the 25th of July 2022. So the first point is to keep in mind when G4S was decided in the context of the pleadings that we're looking at. The second point arising from G4S is the other one that I introduced in summary yesterday, which is that G4S still leaves the precise test and how it falls to be applied in FUSMA Section 90A claims as to who is and is not a PDMR open to be determined at trial. And this is a question that's yet to be determined at trial in any Section 90A claim. And the Lords, just briefly to make that point good, if we can take out the authorities bundle at tab 17 and the decision of Mr. Justice Miles, I think there are just 2 passages in the judgment to which I need to draw your attention. The first is at page 486, at paragraphs 173 to 175. And perhaps I can just invite my Lords to read paragraphs 173 to 175, and then the second passage is over the page at paragraphs 178 to 180, please. I'm sorry, my Lord. It's 173 to 175 and 178 to 180. And my lords, the 2 points I seek to take from those 2 passages in reverse order in terms of the order in which the passages appear in the judgment is first, the elasticity point. That is precisely how you determine who is a de facto director for the purposes of a FSMA Section 90A claim is going to depend in part on a consideration of the purpose of the statute, paragraph 180. So while you've got the decision of Mr. Justice Miles that a PDMR must be a de jure, de facto, or possibly shadow director, precisely how the court will go about determining who is and is not a de facto, and I think it follows shadow director, for these particular purposes under this statute.
I must say, leave aside de facto, how that could be true for a shadow director, I really don't know, because shadow director is defined by statute.
Well, my lord, yes, that's of course right. But what the judge is here is leaving open for trial, as one can see is plainly sensible, precisely how this determination is to be made, because it's better to do it against findings of fact rather than in the abstract on a summary judgment. And that's really the second point arising from the first passage, set of passages, set of paragraphs, is that it's clear that that determination is going to be highly fact sensitive. Now, that forms the backdrop to the pleadings, where, as I indicated yesterday, to an extent the parties, as one might expect, have taken diametrically opposed views. The defendant on the one side still saying only de jure directors, only de jure directors of the PLC. The claimant saying, certainly prior to the decision in G4S, much wider. And still after G4S, so to speak, the issue really very much remains up for grabs. Now, some short points about the pleading. The first is that, as the judge correctly identified in paragraph 68 of his judgment, the claimants do rely upon the group executive, being those people set out in paragraph 70.1 to 70.3 of the particular claim, as being PDMRs for both the relevant misconduct claim and the Maxpower claim. And my learned friend said yesterday that wasn't the case. I'm afraid he was in error there. The judge was right. It is said that members of the group executive were relevant PDMRs for the relevant misconduct claim as well as the Maxpower claim. And my lords, perhaps I can just give you, given the time, some references for that. Paragraph 71.2 and 71.3 of the particular claim, 4 bundle tab 7, page 138. 71.4.5 and 71.4.6 on page 139.
Sorry, those are references for
the particular claim where we rely on the group executive for the relevant misconduct claim. Because I should probably have explained again, although I touched upon it yesterday, why I make this point and why the judge makes the point. We have been asked for further information about PDMRs in the context of the relevant misconduct claim in a way that we have not been for the Maxpower claim. There was then a certain quid pro quo undertaken where we asked Standard Charter for further information about PDMRs relevant to the relevant misconduct claim, and in light of the further information that they provided to us, we then were able to provide further particulars of the PDMR case in relation to relevant misconduct. And so when we're looking at the requests for information, that's the backdrop. They're requests in relation to the relevant misconduct claim, not the Maxpower claim which the defendant was trying to strike out. And this first point was really to address the suggestion that we'd not pleaded a case on the relevant misconduct claim, that PDMRs were members of the group executive. And I'm just giving my lords the reference to where we do plead that. I think I've done 71.4.6, 71.7 on page 141, and 71.8
sorry, 71.4.7.
71.4.6, and then, I'm sorry, I misspoke, 71.7 at the bottom of page 141, and 71.8 over the page at page 142.
At this stage, group executive hasn't been defined.
Well, my lord, I think that's right. It is then defined in the reply, which I'll come to. Those earlier paragraphs feed into paragraph 72. In the circumstances, it's to be inferred that at least one PDMR within the meaning of the ILR, being a board member of SCPLC, a member of Group Management Committee, or other person occupying the position of a director by whatever name called, at all relevant times knew of or turned a blind eye to the relevant misconduct or part thereof. And then at paragraph 73, without prejudice to the generality of the foregoing, 4 at that stage, particular individuals were identified as being PDMRs with the requisite knowledge. And as Malone Frank correctly identified, after we had been provided with further information by Standard Chartered, a further 8 individuals were then identified. But that's all without prejudice to the case that's pleaded prior to that, in terms of who a PDMR is. So, first point, what we now know as the group executive is relied on for both elements of the claim, relevant misconduct and the Maxpower claim. The second point is then to look at the first RFI response, which is in the supplemental bundle tab 19, page 255.
Sorry, Mr. Chapman, give me that reference again.
I'm sorry, Lord, it's tab 19, page 254.
Thank you.
I think I said 255, but we should start at 254 because 254 is where we see what's being asked. So we were then asked some questions in respect of our case on PDMRs in relation to relevant misconduct. And my lords will see what was asked at 19 and 20. And we answered those at page 255. And we simply invite the court to read the 2 responses together, from which it is clear that we are saying that those individuals identified in answer to request 19 are PDMRs, and we are saying in the response to the request 20 that while the meaning of PDMR will be the subject of legal submissions at the appropriate time, reminding ourselves this is before G4S. However, in the case of de jure directors of the bank and members of the Group Management Committee, what's now known as the Group Executive, the roles of those individuals were functionally the same as the roles of executive directors of the defendant. So, even if not de jure directors of the PLC, the members of the Group Executive, namely de jure directors of the bank and members of the Group Management Committee, were individuals whose roles were functionally the same as the roles of the executive directors, i.e. the de jure directors, of the PLC. Now, on the same day as that response was being served, the reply was served, and I'm afraid we have to go back to the core bundle for this, at tab 9, page 317. And it's paragraph 42, And my lords will see at paragraph 42 a response to the defence, which called into question the basis upon which it was said that knowledge was to be attributed to the bank or PLC. And what was pleaded there was that attribution was on the basis that the senior managers were de jure, de facto directors. And at paragraph 43, at the reservation to plead further following disclosure. Now, my lords, all of that...
Just so I'm clear, the deletions by re-amendment, the green, that follows the decision of the judge to strike out that part of the claim that he did strike out.
Precisely so, the four individual named PDMRs at Maxpower.
Yes.
Now, my lords, all of that then feeds into the second RFI response, which is at tab 28 in the supplemental bundle. And the request begins at page 340. Request 1 asked us to identify individual members of the board, the group management committee, and so forth, who are said to be PDMRs. And request 2 asked, in relation to each individual, and to the extent that such a person was not a de jure director, please state whether it's alleged that the person was a de facto director. And the response, again, without labouring the point and repeating myself, these are all requests about relevant misconduct, not Maxpower, which is the subject of the strikeout. But the response then given is, first of all, to identify the 8 further individuals in addition to the 4 pleaded in the particulars of claim. And then at 2.3, to plead that Mr. Shankar and all of the other individuals identified in response 1 above were de facto directors of SC plc at all times, which are material to the claimant's claims, relying on their knowledge and or recklessness. And then the alternative plea, alternatively, if not an individual identified in response 1 above, then 1 or more PDMRs in any event had the requisite degree of knowledge or recklessness. And in this regard, the claimants rely on the following non-exhaustive list of general matters and provide further particulars relating to each de facto director in the subparagraphs which follow. So, going back to the original particulars of claim, the case is that the PDMRs included the group executive for the purposes of the relevant misconduct claim. We have been able to identify within that body 12 particular individuals in respect of whom further particulars have been provided, but we maintain the alternative case that in addition to, or in the alternative to, any of those named individuals, we rely on the other members of the group executive as being PDMRs, and that those PDMRs, or that those individuals fall to be PDMRs, if not de jure directors, then on the basis of being de facto directors. And, my lords, that's a long and I accept somewhat tortuous route through the pleadings, but it does explain in our submission why the judge was right to conclude that it was being said and was pleaded that members of the group executive relied on for the purposes of both elements of the claim, relevant misconduct and Maxpower, were de facto directors to the extent not de jure directors. Lord, that's ground 3. Grounds 4 and 5, I think I can take relatively shortly because they, to an extent, seek to deploy the same flawed reasoning in our respectful submission as the attack on the Brutus allegations, albeit ground 4 does give rise to a particular point. Ground 4 relates to the plea in respect of the relevant, in respect of the group executive in relation to Maxpower and PDMR knowledge. That pleading is to be found at paragraphs 75 to 77 of the particular claim, back in the core bundle at tab 7. At page 146. So paragraph 75, and I'll have to come back to this in a moment on ground 5, pleads the basis upon which it is said that it is to be inferred that the group executive had relevant knowledge of the bribery scheme. For present purposes, what I need to draw attention to is, having pleaded the inference at 75, we then go on at paragraph 76 and 77 to plead compendiously as to PDMR knowledge in respect of relevant misconduct and the bribery scheme, to the effect that at least one PDMR either had knowledge or was reckless as to both the relevant misconduct and or the bribery scheme. And one sees that from the wording at paragraph 76 and 77. And so the judge was right to record at paragraph 73 of the judgment that our case is that at least one or more of the PDMRs within the group executive had the requisite state of mind. Now, the attack on that appears to be that's an en bloc pleading. Well, there are two answers to that. The first is it's not genuinely an en bloc pleading because the case is at least one. It could, of course, be more than one. It may, as things turn out, be all. But the case is at least one had the relevant state of mind. And the second answer is that's a perfectly proper plea as a matter of law. And the authority for that, again, is SOFA, which is, as we've seen earlier this morning, in the authorities bundle at tab 14. And on this occasion, I need to invite my Lord's attention to page 401 and paragraphs 30 to 32, which I'll just invite my Lords to read. But by way of introduction, the claim here was against a corporate trustee, and so it was said that the corporate trustee had the relevant knowledge for the purposes of a deliberate breach of trust, and the objection, substantively the same as the objection being taken by my learned friend, is, well, hold on, that's not good enough, you need to identify the relevant individuals. And the Court of Appeal here said no, that was not what was required. And so with that introduction, perhaps I'll just invite my Lords to read paragraphs 30 and 32. And my Lords, perhaps I'm sorry. I'm sorry.
Yes.
And my Lord, perhaps paragraph 32 particularly in mind, my Lords might recall what I said earlier. On relevant misconduct, Standard Chartered did provide us with further information as to their corporate structure, the individuals involved in relating to the relevant misconduct, and having been given that information, as my lords would no doubt expect us to, we provided further particulars of our case. Entirely consistent with what Lord Justice Arnold is saying here. If, as and when, we get some further particulars, which so far, as the judge rightly recorded at paragraph 71 of his judgment, Standard Chartered has refused to provide, then again, one will expect that further particulars will be provided. But there's nothing objectionable in the way that the plea has been. I think I may have misspoken when I said we've asked about corporate structure. We've asked about the individuals within the corporate structure. Yes, and so the position remains that we don't have information as yet as to the precise corporate structure within Standard Chartered, which my lords may have picked up from the pleadings, is somewhat opaque. My lords, that leaves ground 5.
Is that a very short ground or a longer one? I'm thinking about when to take the break.
I was just looking at the break as well. I don't propose to say much about it, but it may be better for our transcriber if we take a break now. I don't suppose I'll be more than 15 minutes, but that may be 15 minutes too much.
We'll break now.
Right. Morning. As you know, the live stream is still on. Court rise.
Mr. Chairman.
Lords, that brings me to round 5. 2 points seem to be being taken here, although they may again collapse into one. The first is that the claimants plead only that PDMRs were aware of allegations of bribery, and that's not sufficient. And the second is that an insufficient basis is pleaded for the inference of knowledge in any event. My Lords, in addressing those two attacks, one has to start again with paragraph 75 of the Particulars of Claim, Core Bundle tab 7, at page 146, please, where paragraph 75 sets out in its 2 subparagraphs the facts relied upon and the inference that is alleged can and should be drawn from them. Paragraph 75.1, as we've seen, pleads what was said in a journalistic report as regards the awareness of the alleged wrongdoing. So, fact pleaded, inference then alleged. And then paragraph 75.2 refers to a number of different things insofar as they related to several investigations into the bribery scheme in years prior to 2016. And in particular, it pleads that 1, the fact of a whistleblower raising concerns and then being asked to leave and assessment being entered with them, law firms being instructed to carry out investigations and PwC being involved in those investigations. And then, although my friend with respect somewhat glossed over this, the fact of the dismissal of the 3 founding members of Maxpower in December 2015. So the facts are pleaded, and we'll see that these are pleaded in a little more detail earlier in the pleading as well, and then subsequently in the reply. And then the inference alleged, and my Lords, the inference relies on all of those foregoing matters, and also the context, which we see introduced in the words in particular, of the 2012 settlements and the monitoring period in support of the plea that these steps would not have taken place without the knowledge of the group executive. Now, my Lords, the further plea of the investigations and so forth, it appears at paragraph 29 of the particulars, which begins at page 120 of the bundle. And this pleads, first of all, particulars of the bribery scheme itself, but then insofar as relevant to paragraph 75, or particularly relevant to paragraph 75, at 29.5, the fact that during this period, the bank was subject to the monitoring period, I'll come back to that, and it's pleaded that the bribery scheme was at least potentially a breach of the bank's obligations under the 2012 settlement, which required future good conduct and full compliance and so forth. And then paragraph 29.6, the allegation that senior individuals were informed of the allegations of bribery and the appointment of Baker and Mackenzie, which of course then flows into what's pleaded in paragraph 75. Now, as regards to the monitoring period, just some of the laws can see where that's defined. That's paragraph 15 at page 113, where we see that under the 2012 settlements, in addition to the civil penalties of $600 odd million, the settlements impose conditions and ongoing obligations, such as reporting requirements, compliancy reviews, and so forth, for initial 24 months, which was then extended. And that's the monitoring period. So one has to look at the pleading as a whole as to what's being said as the factual basis upon which we say the inferences can and should be drawn. And finally, on this pleading, the particular claim, one also needs to look at paragraphs 76 and 77. So going back to page 147 of the pleading, because paragraph 76 and 77 plead in terms, not just that the allegations relating to bribery were known to at least one PDMR, but that the bribery scheme was known to at least one PDMR. So, returning to the two principal attacks on the pleading, it's simply wrong to say that only allegations of bribery were known to PDMRs. That's not the pleaded case. It's part of the pleaded case, but the pleaded case is that the bribery scheme itself was known to PDMR. Incidentally, even if the pleaded case had been confined to knowledge of mere allegations, then that would suffice, because if a PDMR was aware of allegations of bribery and either turned a blind eye to them and or recklessly caused the published information to contain the statements and omissions relied upon, then that would be enough. But in any event, it's clear on the face of the pleading that what's being pleaded is knowledge of the allegations themselves. Not knowledge, sorry, of the bribery itself, and not just the allegations. Now, further particulars of that are then provided in the reply, which is at tab 9 in this same bundle, page 300. And the learned judge, we say, rightly relied upon this as well as the other paragraphs in the particular claim to which I've been referring, in reaching the conclusion that he did in the judgment. And paragraph 24 pleads out across numerous subparagraphs further particulars, both of the two whistleblowers. One sees in 24.1.1 that the second whistleblower actually sent a letter to SCPLC's audit committee raising concerns after the first whistleblower had done so. And then over the following subparagraphs, various other particulars are given, both of the bribery scheme itself, but also as to steps taken to investigate, and then ultimately leading to the dismissal of the founders in response to at least some of those investigations. And that's pleaded over, as I say, several subparagraphs. My learned friend alighted in particular on paragraph 24.4 on page 301. And he said, alighting upon the first sentence, where it's pleaded that it's denied that the claimant's allegation that senior individuals at the bank were informed of allegations of bribery is inadequately pleaded, and said, aha, there you are. The claimants recognise that their case is not that PDMRs knew about the bribery, but knew only about the allegations. That's wrong, as we've seen. Paragraph 76 puts the position beyond any serious doubt that what's being alleged is knowledge of the bribery itself. And although this is somewhat arid, paragraph 24.4 is pleaded as it is because it is a reply to paragraph 31.5 of the defence, which itself pleads to paragraph 29.6 of the particulars, which we were looking at. And paragraph 29.6 of the particulars, as we saw a few moments ago, does plead an allegation that allegations of bribery were known to PDMRs, followed by what we've seen in 75 and 76, the defence then said that allegation in paragraph 29.6 is inadequately particularised, to which the claimants then replied at 24.4. And indeed, even within 24.4, as one sees 6 lines down, the sentence beginning further, there is a reference back to the basis for the inference of PDMR knowledge pleaded at paragraph 75 of the re-amended particulars of claim. So, my Lord, we say, fairly read and applying the test as summarised in SOFA again, this is a perfectly adequate plea as a pleading, and the judge was right to conclude to that effect at paragraph 73 of his judgment. And so we say it's a perfectly proper plea that at least one of the group executive knew of the bribery itself, and the basis for that inference is set out. My Lords, we've made some other points in our skeleton, that those I think are the principal submissions I need to address to my Lords orally as to why we say ground 5 also falls to be dismissed.
Let's ask you one aspect. You referred us to SOFA, and in particular paragraph 32, tab 14, page 4 2.
Yes.
Where Lord Justice Arnold says that where an allegation of dishonesty is made against the body corporate, it is necessary to keep the relevant state of knowledge of that body at the relevant time. For me, to identify at the outset the directors, officers, or employees. And I think you relied upon that in relation to the ground 3.
It's ground 4 principally.
Many questions this up, but I entirely understand that where an allegation of fraud or dishonesty is made against the body corporate generally. But in this cause of action, there's a specific requirement. There's only liability if there is dishonesty on the part of the PMR. That's a specific element of the cause of action.
It is, my Lord.
I wonder whether or not that principle applies, or it certainly applies to the same force.
Well, we say it applies by analogy here, because just as in the case being considered by Lord Justice Arnold, the body corporate can only act through its natural persons, and so ultimately a natural person will have to be identified with the relevant knowledge.
I understand that, but the allegation there is made against the body corporate, albeit acting for an individual. But in the Section 90A claim, you can't do that. You have to demonstrate it's an element of the cause of action that an individual PDMR has that dishonest state of mind. So I wonder if you can just say, well, we allege it against the body corporate, we don't allege it against an individual. I can see you might be doing it by inference.
Well, look, dealing with the last point first, we do by inference, but because we say effectively here, look, this was so serious, and given the backdrop against which it took place, somebody fulfilling the definition of a PDMR must have known. So we do that in any event. But dealing with the prior point, we do say by analogy the same position applies, because the statute is effectively providing a statutory cause of action, identifying corporate liability as liability on the part of the issuer, which is dependent upon the issuer issuing published information that's misleading or contains omissions in circumstances where a particular type of person within the issuer has knowledge. Effectively, it's setting the statutory threshold for whose knowledge is relevant for the purpose of the issuer's liability. And so we say the position is analogous to that being considered by Lord Justice Arnold.
Thank you.
Thank you very much, Mr. Chapman. Mr. Beltrami.
Lord, yes, we submit that the process of exchanges with the claimants have exposed the fundamental flaws in this manner of pleading and its insufficiency as an English pleading of fraud, turning into each of the three heads of Rule 3.4, if it matters. And as your lordships and I are familiar, there are two pleadings of fraud wrapped up into in this case: the underlying Brutus fraud and the PDMR fraud, each of which must be subjected to the scrutiny that SOFA requires. The three problems that have been exposed through the exchanges we submit and remain as follows. First, as a matter of pleading, this has been a lot of the discussion, and it's the beginning of the problem. Paragraph 24 merely pleads the fact of the Brutus allegations, i.e. an allegation, as your lordship put it, of an allegation. That's, as I said yesterday, it's not where I hang my hat, but it's the start of the problem. And the exchanges with the court exposed why that form is deeply problematic for a fraud claim, in that the court had to ask from their friend whether they did adopt the Brutus allegations as their own through this form of pleadings, and then if so, which ones? I.e., in fact, on a strikeout appeal, what the pleading actually meant. And with all due respect to my friend, it was clear from the exchanges that faced with the question, the claimants were not even sure what the pleading actually meant and had to go off overnight to think about it. That doesn't get me home entirely, but frankly, on a strikeout appeal, that should not be a position in which the parties are faced, and it's the consequence of this form of pleading. So that's the first problem. The second problem is if it's to be treated, as was alleged, as pleading by adoption of those Brutus allegations. We do maintain the case, and nothing we submit to the contrary was said, that the mere pleading of allegations by Brutus, or the reliance on allegations by Brutus, as alleged, does not disclose on the face of the pleadings a solid evidential foundation for those claims. The particular objection we put is not, as it was said in answer, that we're simply saying the claimants couldn't rely on a third-party witness of fact, a traffic accident, for example, or even necessarily, Lord Justice Phillips' example, the bank manager who had specific evidence about a fraud, for example. The Brutus claim, which is the foundation of this allegation, contains a series of highly controversial allegations based ultimately on the apparent, though largely unexplained opinions of two individuals who are making a claim, as we know, for hundreds of billions of dollars. Such that, and the consequence is, the bare assertion by the claimants that their position is that the Brutus complaint is all true demonstrates nothing more than the hope that those untested opinions are accurate, especially in the circumstances, my Lord Justice Phillips pointed out, that the claimant in that proceedings considers they are meritless. And that's one of the reasons I focused in my submissions on this specific point. It's easy to speak to approach this as a matter of generality. My friend said a lot about context and all the rest of it. What I sort of focus on the specifics, and the specific point, which wasn't, to my mind, responded to at all, about US sanctions. The premise of the entire Brutus complaint is that the various transactions they identify were in fact breaches of US sanctions law. They say a lot more than that, of course, but without that linchpin, the whole complaint dissolves. The evasion, etc., is no longer a question if they can't get over that first hurdle. It is known that that is, to put it at its lowest, a controversial issue in circumstances where the person responsible for the US government agency managing the very sanctions regime they're talking about has considered that the complaint discloses no breach of sanction at all. In those circumstances, it's necessary, we submit, to bring a measure of realism to this case. In a properly pleaded fraud claim, and let's move into that world for the moment, a claimant who wishes to allege sanctions evasion would have to identify in an English pleading and plead out the sanctions law, the transactions which breached the sanctions law, the basis on which they were breached, and the facts and matters supporting the case that this was a matter of evasion, i.e. deliberate breach, if that's going to be alleged as well. That is how a standard English pleading would look were that serious allegation to be made.
Can I just ask, I follow how you put that. Is that actually within the scope of this appeal or possibly the application?
Well, it is to this extent, if I can say, they haven't, we know as a fact they haven't pleaded that out. They haven't pleaded out what we submit would be the starting point to make that allegation in their pleading. What they have done instead, and it goes back to the form of pleading, is something different. They've said, well, Brutus says that. That's the instead of pleading out what they ought to plead, they've pleaded, well, Brutus says this. Now, and we say that simply can't be enough as a solid foundation for the case. In contrast to what, in a normal case, they would have pleaded, they've relied on a third-party view instead. So that's what we say is the problem.
I mean, sorry, go on.
I was going to say, I understand that submission, but if that was right, there should have been an application years before the application was actually made, or at least a year before the application was actually made, if it was so fundamental.
Lord,
That's what I struggle with. I understand that submission completely, but why did this case go on for so long with pleadings, detailed pleadings,
well, Lord,
from the defendants?
I was going to come back.
And then suddenly, this change of mind. I mean, it looks dangerously like game playing.
Well, I was going to come back.
The solicitor doesn't look very impressed, but it looks dangerously like game playing. Can I
Lord,
repeat?
I was going to come back very briefly, in fact, on the sequence of events. And looked at from here, there has been a delay, but as I said earlier, and I will go back a little bit of detail of that certainly wasn't down to the defendant in this case. But I will address that more. I understand the point, but it's, with respect, wrong on the facts. But I'll come back to that.
Okay. Just going back to where you were one moment. So the two grounds of appeal that are relevant are first, they should have refrained from pleading speculative allegations lacking a sufficient evidential foundation.
Yes.
And second, no primary facts.
Yes.
Now, if we suppose, for the sake of argument, that we effectively read in parts of the Brutus complaint to the pleading, the point you were making a moment ago really goes to whether or not that's sufficient as a pleading. It doesn't obviously go to whether or not there's a sufficient evidential foundation or whatever. It's saying, well, you really should have explained which US sanctions were breached.
Well, it does with respect to this extent, and that's why I wanted to contrast with what I would say would be the right way to plead the case. To put the points in issue would be to plead the sanctions and identify the breach. Now, in theory, to put this in two opposite terms, well, if a party adopted someone else's claim, so be it, that material could be said to be included by way of adoption. What we have here, though, is what they have adopted doesn't do that either. So instead of pleading what they ought to have pleaded, they've simply pleaded, well, Brutus says this. If you go to see what Brutus says, Brutus hasn't identified those materials either.
But well, let's take that first ground of appeal.
Yes.
Is this point really to do with that first ground of appeal? The first ground of appeal is there's a lack of a sufficient evidential foundation.
Well, yes.
Well, now the complaint is not lack of a sufficient evidential foundation. It's, well, you should have given further particulars. You should have explained which sanctions were being breached. That's a different complaint.
No, with respect, we submit it isn't, because in order to advance a fraud claim such as this, the evidential foundation for the claim must be pleaded. That's what those cases that we looked at says. Now, we submit that if a party seeks to allege a fraud based on sanctions breach, the evidential foundation for that claim must, at the minimum, identify what the sanctions were and how there was a breach. That's not a matter of particulars. That's a basic evidential foundation of that claim. So the question, and there's more to it, of course, than that. This is why I wanted to focus on this point in particular. The question is that pleaded as a foundation for this very serious allegation? Even before we get to the questions of deliberate conduct, as a foundation, was there a breach at all? Now, they haven't pleaded it themselves. They've simply said, well, Brutus have made these allegations, which takes the question, well, what have Brutus said about sanctions breach? Have Brutus engaged with the questions of sanctions breach? And the answer to that is no as well. If you go back to, probably for the last time, I hope, the Brutus complaint itself, save in one possible respect, they don't explain what the sanctions were and how they were breached. What Brutus plead in their complaint, and let's run with the assumption that there's an adoption of this or some of it into this pleading. Paragraph 35 page 35 of the supplemental bundle, paragraph 8, refers to, or just alleges in paragraph 8, that there were a number of US sanctions which were breached. So you see the assertion in the middle of the paragraph. That's just an assertion of what the sanctions were because of their links to Iran. And then if you go on to a paragraph we did look at before, paragraph page 45, paragraph 42b, Brutus allege, as you may remember, that the law doesn't allow for winding down of illegal sanctioned transactions. These transactions are crimes that must be halted. So if one asks the question, how should this pleading be set out to give it a solid evidential foundation, at least to show there were sanctions breaches? They haven't pleaded it. They've said, well, we rely on Brutus. That's all Brutus has said about it. And we submit that doesn't give rise to a solid evidential foundation of sanctions breach. And therefore, the allegation by the claimants that there was sanction breach is just a guess on the face of the pleading. There's nothing to support it on the face of the pleading. That's why we say it's not a matter of particulars. It's a matter of lack of evidential foundation. It's made worse in this case because, your lordships may remember yesterday, paragraph 42b is one of the paragraphs he doesn't rely upon. Expressly is not adopted into this action. So what on earth is that? Are they adopting and not adopting? They're not adopting this single paragraph where Brutus says something about sanctions. So what is the case they're advancing to this court as a foundation of a fraud case, that there was a sanctions breach? It's unclear. It's completely unclear because there's nothing at all is said about the case, either directly or by adoption. And that's why we say it's not a matter of, well, they've pleaded something, but not enough particulars. Right at the core of this case, there's a void. And that's an example of the sanctions point, but don't want to spend time. We submit it goes across the piece. It's simply assertion without detail. And absent fundamental matters such as that, we submit the case can't survive. My Lord Justice Coulson asked the question, how does a trial judge deal with this partial adoption of Brutus? And the sanctions point is a great example of that. Because what is the trial? What is the case on sanctions breach? What is the case they're advancing? Is it the same case as this, which they're expressly not adopting? Is it something else? If so, what it is? And the question isn't just a matter of the trial judge, of course. The question is a matter of the defendant. How does the defendant address this fraud case, not knowing the beginning of the sanctions breach which is alleged? So that's we say the solid evidential foundation as example in the sanction, say an important example of the sanctions breach. The third problem is back to the absence of primary facts problem, which your Lordship knows. And with respect, that has never been properly addressed, we submit, certainly wasn't addressed by the judge, who ultimately, your Lordship remember from the judgment, thought we couldn't run the point because of the case memorandum. And it wasn't addressed, we submit, by the defendant, by the claimants. And the answer this morning was that the defendant hasn't properly identified what facts would need to be pleaded in order to support this case. But that's the wrong-headed approach to a fraud claim. Insofar as they're alleging breach of sanctions, obviously, they need to allege the things I mentioned. Insofar as they're alleging knowledge of breach, for example, they need to allege facts which support knowledge. That's just a matter of fundamental pleading. It's not for the defendant to say, oh, well, you haven't pleaded this fact, but you could have pleaded on that fact. It's always for the claimants to identify the primary facts. And we do submit, and I won't go back over the period of the substance of it, that the allegations of fraud are pleaded by way of inference only, and are pleaded by way of conclusion only. They're pleaded by way of conclusion in paragraph 24. Your Lordships are very, very familiar with that. It's a pleading in the most general terms. But it's equally pleaded by way of conclusion in the Brutus claims. Because the Brutus claims make sweeping allegations of dishonest conduct and knowledge of this and knowledge of that, none of which are primary facts. The inferences we submit from primary facts which aren't pleaded. Still on the Brutus complaint, we spent quite a lot of time yesterday looking through paragraph 24, 42 and 43, But just to pick up, as it was confirmed that subsequent paragraphs were being relied upon also, if one picks up, for example, paragraph 47, one of these supposed transactions, transactions would be an area, in principle, where one is getting into facts. So as opposed to sweeping allegations of dishonesty, one is, hang on a minute, if you're talking about transactions, at least we know what you're talking about. But then look and see what they said about these transactions. The 47, for example, they performed an export finance transaction. Such a transaction necessarily involved dollar clearing. So there's a statement about a transaction being performed. There's then an interpretation of what that transaction would have involved on the basis of someone's opinion somewhere unexplained. And there's something unsaid about why that was a breach of sanctions. So it's no good to say, well, we rely on that too, and that's a fact, because the fundamental parts of this claim are not pleaded in Brutus either. Let me also show you on this. We focus quite a lot on the Brutus fraud, if you like, but always remembering they also need to prove as a matter of pleading, or they need to prove primary facts to support as a matter of pleading, the PDMR knowledge fraud. There is no doubt, lest it were otherwise thought in relation to Brutus, that the PDMR knowledge claim is a claim by way of inference. Because they have, well, if you go to the further information, second information, tab 28, paragraph 3, which is on page 349. They were asked to identify the PDMRs who they said had guilty knowledge, on the basis of which that allegation was made. So they're asking for particulars of the primary facts in support of the allegations of dishonest knowledge. So they've sought to identify, in this part of the paragraph, presumably those primary facts, if any, which they can rely upon in support of the allegations that PDMRs had guilty knowledge of the Brutus fraud. Another critical part of this pleading. What have they done by that pleading? They've identified 3 of these, of the 12, who are said to be linked to Brutus. So the PDMR dishonest knowledge claim in relation to Brutus, certainly by way of express pleading, relates to 3 of them. And the first is Richard Meddings. And you'll see in paragraph 3.2.1, it said that Richard Meddings, at the bottom of that page, is referred to, is named in the Brutus complaint. That's true if you can keep your finger, I'm afraid, in that 349 and go back to page 37 of the bundle, which is Brutus.
Sorry, page
37. Which is paragraph 13 of Brutus. So the question is, what my friend said, what are the primary facts? Well, they've sought to identify the primary facts, it seems, in relation to the inference which they admit that they're seeking to draw. In relation to Mr. Meddings, he is referred to in paragraph 13 of the Brutus complaint. You'll see what's said there is a quote from Mr. Meddings, which actually appears in the 2012 settlement. So I think it's just put in here as a sort of prejudicial point. It doesn't actually deal with Brutus per se. It's a comment on something what's an observation on something Mr. Meddings said in a very general sense, as you can see. Going back to 349, 3.2.3, it says at the bottom of the Brutus complaint states that Mr. Meddings had knowledge of Project Green. I'm afraid I couldn't find that. I may just be an error about that. I couldn't find that reference at all. If there is one, sorry about that, but I couldn't find it. 3.3, the next individual referred to as Mr. Rees. They said he's recorded in the Brutus complaint as being involved with Project Green and the Iran group, and being at least a person to whom information about the Iran group was circulated. And therefore, if you go back for these purposes to page 45, (42) D, which I think is one of the incorporated paragraphs, there's a reference to the Iran group maintained separately all of the management information systems concerning SCB's Iranian client transactions. The MIS disseminated this information throughout, from low-level employees up to the deputy CEO, Mr. Rees. Now remember, of course, it's not in dispute that there were certain Iranian transactions. Remember, the US government said, well, they were wind-down transactions. But the allegation against Mr. Rees, in support of the allegation of dishonesty, is that Brutus says he received information about Iran. That's what's relied upon in relation to Mr. Rees. And finally, if you go back to 350, Mr. Shankar is the third of the Brutus, supposed Brutus PDMRs. And the reference at 3.4, Mr. Shankar, refers to the fact that he was group head of the OCC in Dubai, and that the second amended complaint says something about the OCC. And it does, if you go back again to 45, paragraph B, there's a reference to the OCC, but there's not actually a reference to Mr. Shankar at all. So, and that's it. So, plainly an inferential case of dishonesty, but as soon as one burrows into the detail of this case and says, what are the primary facts in support of this serious allegation of dishonesty against PDMRs relating to Brutus, that's the pleaded case. And that's symptomatic, we say, my longer submissions yesterday about Brutus being conclusory, etc. When asked to identify the facts, that's all we get. And we submit that, going back to the test we looked at, the SOFA test, that can't possibly be sufficient to tilt the balance in favor of dishonesty against those three named individuals. And if they can't do it for the PDMR fraud, the case is hopeless all the way through. Well, that's all I wish to say on the if you like, the substantive bits of the Brutus point. Briefly on the question of delay from my Lord Justice Coulson's point of view, and only to say what the chronology was to this extent. There have been 4 claim forms in this action. One of the reasons is different claimants sort of drop in and drop out a little bit, and names change, etc. The first claim form was the 30th of October 2020, and the 4th claim form was October 2022. So yes, it's been quite a long time to the first one, but the actual final one at least was October 2022. The particular claim wasn't served until November 21, and there was a defense in February 22. As I said yesterday, on the 17th of June 22, in the context of discussions about the DRD, the defendant expressly reserved the right to strike out the Brutus claim. It's in the bundle, but you don't need to go to it. Early in 2023, the CMC was listed at the defendant's initiative. There's been quite a lot of momentum not happening in this case. The defendant listed the CMC, and we got the date for October 23. And the application was issued on the 7th of July 23, 3 months in advance of the CMC, which is obviously the right time to deal with the application. So, looked at.
So on that basis, the application could have been made in June 2022, because you don't advance pleadings by solicitors' letters.
No, your Lordship was right. The application could have been.
That's when the application could have been made. But so you say, yes, you accept in that sense there was some delay, but you say it's not as much as on the face of it looked.
Well, I think 2 things, your Lordship. Not as much as it looks on the face of it, but also the appropriate time to deal with it was at the CMC. So it was never going to be heard until the CMC, and it was actually the defendant who got the CMC listed, and we got the October date. So yes, your Lordship is right. It could have been done earlier. It would have made no difference to the sequence of events, because the CMC would still have been the appropriate time to deal with it, as opposed to a separate application. Last point of Brutus, my friend mentioned something about the impact of striking out Brutus and whether it would make or wouldn't make a difference. We do submit it would make a significant difference. First of all, it's a serious fraud case anyway, and therefore if it's wrong, it ought to go. Secondly, it is likely to make a significant difference to the scope of the action. As your Lordships are aware, the 2019 settlement agreement material is agreed. And therefore the question is, did that constitute breach of implied representations? But also, did PDMRs have guilty knowledge in relation to that? In relation to Brutus, as you also know, first of all, it's on a massive scale compared to the 2019 settlements. As I mentioned yesterday, $620 million versus hundreds of billions of dollars indicates just to some extent this scale. Secondly, that's all in dispute. there's a new list of issues for disclosure following the strikeout application. Specifically, were the Brutus allegations true, which introduces a whole new inquiry, which is nothing to the point in relation to 2019. I'm told that on that search term alone, specific Brutus relating search term, that generates 140,000 documents and 340,000 with families alone in relation to the current document set. And there are going to be other document sets abroad. We also know, for example, if you go back to core bundle, supplemental bundle, tab 18, page 147. Supplemental bundle, tab 18. Nope, push it, give me 1 second, I apologize. Sorry, it's tab 10, page 147. This is Mr. Knight's statement. And he indicates at paragraph 34 that he supplied, amongst other things, over 50 witness names to the US government authorities. And at page 148, paragraph 37, he also refers to enormous volumes of SCB records beginning with first translations, etc. So there can be no doubt about the exponential increase in the inquiry. Indeed, even as from this morning, if you go back to the Brutus complaint itself, again, promised for last time, and go to paragraph 58, page 50, one of the paragraphs that is about being adopted, you see a very general statement from Brutus listing a number of names and identifying the quantity of a number of transactions alleged to be illegal. So all of a sudden, the inquiry will involve searching or looking into each of these names and each of these possible transactions to see if they're illegal for some so far unexplained reason, quite apart from anything else. And in circumstances in which Mr. Chapman said this morning, these are only examples of what they expect to be investigated in the Brutus complaint. It really is a piece of string as long as you want to pull. So that's all on Brutus. As far as Maxpower is concerned, and the first point was the G4S point. My friend took you to Mr. Justice Miles's decision and referred to the point about the reference to elasticity and it being fact sensitive. The G4S point, as we've taken on this appeal, is not that the matter can be resolved today as opposed to go to trial. It's just that it's not pleaded at all. So the elasticity of a pleaded case doesn't need to be worried about when the point is we haven't pleaded it, they haven't pleaded it. And with respect, my friends trot through the pleadings this morning didn't indicate how there was a pleaded case, that any of those group executives were in fact de facto directors, let alone the basis on which that allegation was being put. However, the allegation that was said this morning was a matter of, I must say, real concern and symptomatic of broader issues, which is that the submission made, as I understood it, was that there is a case being alleged that the group executive knew of Brutus and were dishonest about Brutus. You ought to recollect that was the allegation being put this morning. Now, 2 points about that. It's not just, well, let's just follow it through. We submit it's just wrong as a matter of pleading. But if it's right, it's a terrible, the pleading is, in this respect, also wholly defective. And one can see the difficulty of just banding around such allegations. Can we go, please, to the particulars of claim?
My Lord, to be clear, that what I said this morning was that there was an equivalent plea of PDMR knowledge based on the group executive in relation to the relevant misconduct. And so the same analysis applied to relevant misconduct and Maxpower.
Well, I think that needs a clarification. Another friend saying that in relation to Brutus, because Brutus is part of the relevant misconduct.
I didn't need to descend to that level of detail, my Lord, because the point I was making was that there was a plea of de facto directorship in relation to the group executive, insofar as it is alleged that the group executive are PDMRs for the purpose of the relevant misconduct claim. And so the same approach was being applied on both. I don't really think they need it.
Well, if you go, please, to...
Just to be clear, Mr. Beltrami, I follow this as a matter of concern. Is it one that we're going to be deciding?
Lord, it's relevant to this point, and maybe I only put it on as an additional point, that it's a further indication of the inadequacy of this form of pleading. Your Lordship knows what I say generally about Brutus, but this is just yet a further indication of all the problems that one gets into following this form of pleading. Because the submission this morning confirmed he is alleging, as he wants to allege, that the group executive had knowledge, therefore guilty knowledge, of what he calls the relevant misconduct, which obviously includes Brutus. So he is saying that is part of their case. Now, can I take you, briefly, because I want to finish, Your Lordship, want me to finish? 144. Full bundle 144, paragraph 17, which you are achingly familiar with, I suspect, is the first suggestion in relation to relevant misconduct that they consider the following individuals were PDMRs with requisite misconduct. And that's the four: Meddings, Rees, Shankar, and I think somebody else. We then go to the further information at supplemental bundle 340. Starting, if I may, with the question at 340, which is...
Sorry, since I've been difficult, I'm stuck with the bundle I originally
Sorry,
had. Is this the first request or the second?
Second further
Second
information.
request. Yep.
First question is, which individual members of the board, etc., do the claimants allege knew of or turned a blind eye to the relevant misconduct? So the specific question is, who do you say had the relevant knowledge? And the third question is, in relation to those who you say had the relevant knowledge, what's the material in support of it? And that gives rise to the Brutus points that we looked at earlier. The response at 341 is, doing the best they can, etc., the claimants allege the following individuals knew of or turned a blind eye to the relevant misconduct. And they then identify the 12. That's their case. That's their allegation, it's the 12. They then say, if you go on to paragraph 3 on page 348, which we looked at briefly for Brutus, why they say each of the 12 had the relevant knowledge. Now, there is no pleaded case in answer to that question, and everyone else in the group executive as well. That's not what they say. And if this is to be pleaded as if it is what they say, then it creates all the problems we looked at in Brutus. For example, how can they allege that 50 people in the group executive suddenly had knowledge of Brutus? It's not a pleading at all. It's not pleaded, so to that extent, it's not a problem. But the fact that it's thought that it is pleaded is symptomatic of a problem of a pleading of this nature. Brutus doesn't say the group executive knew all about the fraud, for example. The group executive wasn't a body that Brutus even knew about. So it is a bit of a side issue, and Lordship is right. But given what was said, it's sort of important at least to mention it. Last 2 points on Maxpower. Manfred said, I wrote it down actually, in answering the question, have they pleaded a case of knowledge of the bribery as opposed to knowledge of the allegation, submitted that they pleaded a case of knowledge of bribery, and you know what we say about that. But he then said that a pleading of knowledge of the allegation would suffice if the PDMR turned a blind eye or was reckless about the allegation. I wrote it down for what it's worth, but the conditional, the way it was put, gives away the problem. Yes, it would, on that conditional, but the claimants would have to plead that the PDMR did turn a blind eye or was reckless to the allegation. And that's what they haven't pleaded, and that's what they haven't supported by any particulars. So it's the absence of that case, either expressly pleaded or supported, that creates the problem. And the last point on Maxpower, and unless I missed it, My friend didn't say anything at all about the question is, does paragraph 75 support the pleaded case? I mean, he said it's all about context, and he took you to the monitoring period and all the rest of it. The fundamental point remains, looking at paragraph 74, does that tilt the balance in favour of an allegation that these 50 people are dishonest? And if it's as simple as that, the answer must be no. And with respect, I didn't hear anything today that said the contrary.
Did you dare say paragraph 74? Did you mean
75.
paragraph 75? Yes.
Well, those are my submissions and reply.
That's very helpful. Thank you very much. I don't detect any further questions. You won't be surprised to know that we won't be giving judgment today. You, in accordance with normal practice, will be supplied with the judgment and draft to go to the addresses which you have already provided. And I know that you will already be aware of the importance which is attached to compliance with the embargo. So were it thought desirable to provide the draft to anyone extra, you should obviously come back to us for permission to do that. We'd be grateful if, once you had the draft, you seek to identify errors in English and typing. You shouldn't, of course, seek to re-argue the points. We'd also be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to rule on the points in the order that we make. But thank you all very much for your submissions.
Well, thank you.